So, dear friends, we can start our session, Law and Economics, and it's my great pleasure to introduce our guest today on our Gaidar Forum. This is Professor Leitzel from University of Chicago, United States, Professor McKay from University of Montreal, Canada, and our big friend, Professor Amato, twice former Prime Minister of Italy, and former twice, and Honorable Doctor of our Academy from April 2017. So, our discussion, I think we can start with Professor McKay. Yeah.
Can you all hear me? Thank you. First of all, thank you for coming to listen to me, and please accept my apologies for speaking to you in English, because Russian I haven't even tried to learn. When we planned the panel, we were given the task of putting a fairly simple introduction to law and economics on the presumption that you might not have great knowledge of it. So my presentation will be quite simple. But to give you a sense of what that law and economics resolution was, why it came about, what it can do. So here we go. That's the English book, of which a Russian translation is going to appear in March or April. Unfortunately, not yet, but apparently, I'm told by the publisher, you can already order. But that's the original book, from which the Russian translation was prepared. There have been, over the course of history, a number of attempts to try to understand law with the help of concepts derived from economics. Economics are the analytical engine used to get a better grasp of law. Names you may have heard: Bentham, the institutionalist, first in Germany, France, then in the United States. All of those, I think, have not been nearly as successful as the current wave. The current wave started in Chicago, was an initiative of economists venturing outside of their traditional territory. And if you look at it now backwards to say, what was it that made this movement successful this time? I think there are two discoveries that we might stop and discuss for a moment. The first discovery was that when you looked at common law doctrines, as they were understood, many of them looked efficient in the sense that economists by then had recognized as a key concept within economic theory. Now you might say that's a remarkable discovery, scientifically very interesting, but that would never have got lawyers interested in it, because lawyers, there's a very special cast of mind. So we took a second discovery to get the lawyers in. And what was that discovery? Well, it was that many of the rules that promote efficiency, as economists understand it, correspond to our intuitive sense of justice. Now, if there are lawyers amongst us, I don't want to play this as a public game, but how many of you could tell me in 2 sentences what justice is? Well, many of you would say, no, well, that would take us days. Justice is it's a difficult to trace concept. And so the promise that law and economics held out in the beginning was that you could get a handle on a concept that for lawyers was notoriously difficult to grasp, get a detailed handle. Let me illustrate with a simple example. Apologies to Jim. In the law and economics literature, it's often referred to as the Himalaya expedition, but I like to refer to it as the Polar Bear expedition. Imagine the following story. We're living in the middle of the 20th century. a time when photographs were still taken on sensitive rolls and then developed in specialized shops. You have become convinced that the polar bears are going to be extinct. And you say, before this happens, I need to take photographs and even film these animals. So what you do is you organize an expedition, several people, cameras and so forth, and you go to Toronto in Canada. Then you take a flight 3,000 kilometers north, and you're not far from the pole, and that's where the polar bears are. You photograph the polar bears, you come back to where you came from, and then you have all these rolls full of pictures and films, and you bring that to a shop for development. And most unfortunately, the shop messes up the rolls. So there are no photographs. And then the organizations that sponsored your trip say, hey, we have a problem with you. Legally, you say, well, can I hold the shop liable for the damages that I sustain? I don't know what the expedition might have cost, $1 million, you thought? $500,000, $1.5 million. Anyway, a substantial sum of money. And so what would lawyers say to that problem? The lawyers would say normally, yes, but if you have a contract, even an implicit contract, the damages you can claim are limited to what was foreseeable at the time of contracting. Now, if you have these films developed in a shop that normally does family pictures, wedding pictures, that sort of thing, they do not expect damages in the order of $1 million. So they might say, oh, you may be entitled to $5,000 at most for something. That is, to our lawyers' sense of justice, that is the fair solution. And what's the economist's take on that problem? Well, the economists would then say, what happens if you hold the shop liable, and what happens by contrast when you hold the expedition organizer liable? First of all, what happens if you hold the shop liable? Well, the shop suddenly is burdened with an enormous amount of damages to pay, and they say, well, for the future, we'd like to avoid this. So what can they do? Well, they can adopt more elaborate procedures, put in place more expensive equipment. They can insure themselves for that sort of damage. But for most of the clients of that shop, that's totally wasted. They don't need that extra precaution. Now contrast that with the idea that you, as an expedition organizer, cannot claim damages against a shop. What's going to happen now? Well, you as an expedition organizer are now going to take the precautions. So you're going to make sure that for any scene, you have several photographs, several films. And when you come back, you may give different films to develop at different shops so as to spread your risk, as it were. You may insure yourself for this risk. When you compare those two situations, which do you think is the least costly option? What's the more efficient one of these two solutions? Well, obviously, holding the expedition organizer liable is probably less costly. It focuses the incentives for precautions more on the person who's best placed to do that. Lo and behold, the efficient solution is also the one that seems to correspond to what lawyers think is fair, just. So that was the insight that drove, I think, lawyers to get interested in this whole movement. Now, once the law and economics movement got started, Richard Posner wrote a first overview of the whole of the law, essentially, intended for lawyers. You might ask, what's the message that law and economics conveys to different groups? And my point to you here will be that law and economics has not the same message for economists as it has for lawyers. To economists, it says, essentially, the institutions that form law can also be analyzed with the equipment, the intellectual equipment that economists normally use. And they are not something fixed outside the economy, but they form part of the choices that economists think we make. So for economists, it's simply an extension of things they already did. But to lawyers, it's a different story. Lawyers normally ask the question, any problem they're faced with, what is the applicable rule? Where do we find the applicable rule? Which is it? And now, law and economics brings them an entirely new complementary question. What are the social effects of a given rule as against a different rule or against a contrasting rule? So lawyers have an entirely new reality brought to them by the law and economics movement. Then let me say something about what law and economics has to bring to civil law countries. Because if you are familiar with some of the economics literature and some of the doing business literature that the World Bank has published, sometimes odd things have been said about civil law countries, as if we were sort of monks working through endless lists of statutes and so forth. That is not the point of the civil law tradition. The civil law, why do we have codes? Well, initially the point of civil and other codes was to simplify access to law. And that in itself, you might say, has efficiency value. That is something economists ought to be sensitive to. Precisely what do codes intend to do for your law? They systematize rules. You put them in an order, so it's easier to learn about them. You simplify their formulation. Code rules are meant to be easy to memorize and to understand. You summarize many particular rules into one single formula that's perhaps a bit more abstract, but at least summarize it all so as to make it more easy to understand it all. And then you resolve contradictions as you make a civil code. When people plan a civil code in these commissions, they resolve contradictions. Law doesn't like to have contradictory rules. So when you set up a code, you want to avoid these contradictions. And that in itself has economic value, might say. So that a code normally forms a coherent and a gapless web of rules. All problems within a certain area, normally, that was the original idea, of course it turns out to be an illusion, but all problems within a certain area find some form of solution, some anchor for solution within a code. That was the point. In that sense, it made access easier. And so, what do you train lawyers to do in the civil law tradition? Find their way in these webs. Yes, they're a bit more technical. I mean, they rely on texts and so forth, but the texts are meant to help you find your law more easily. In the civil law tradition, you want any solution to a particular problem to have an anchor within the code. Perfectly normal, given the point of the code. What it means, though, given the design of the codes, the civil code should be eminently amenable to law and economic analysis. The policy choices that law and economics goes after should become apparent as you apply economic analysis to civil and other codes, commercial code, procedure codes, and so forth. Law and economics can bring out the implicit policy choices that underlie the code. So now, what can law and economics do for us now? And that will be the last slide we have. When a new field of law needs to be regulated, we're talking about law applicable to cyber commerce and so forth, you need to do policy analysis. At that point, the law and economics scholarship is the best tool we have. Law scholarship in itself, having coherent rules and so forth, that's not the best tool we have. When we want to do policy analysis, you must use law and economics or some complementary tool. Absolutely essential. But once we have analyzed the choices there are, and once we've made those choices, then we want to freeze into place the solutions that we have come up with the idea that it's easier to apply a written rule as it's normally understood to all sorts of practical problems than to try to do a policy analysis for any dispute that might arise. There is parsimony, there is the economic value in having reliance on text for run-of-the-mill problems. But, you might say, over time, rules that were adequate when they were first drafted may come to, how should we say, become dissonant with new realities. Technology throws up new possibilities, social customs may change, so legal rules may come to be out of tune with realities. What do we do then? Well, lawyers then need a sort of an alarm system to tell them it's time to change. Change either by interpreting rules before the courts differently, or even do law reform, get it to Parliament and change the rules. What's that alarm system? Now there again, law and economics provides that alarm system. Very useful thing. Law and economics has other uses. Am I allowed 1 more minute or 2 more minutes? It's for legal scholarship, doctrinal work, it's very good in bringing together rules that have similar functions or understand incoherence amongst rules. For doctoral thesis, law and economics is a fantastic engine to generate a theoretical structure to bring all the material into some sort of picture that you can work with. Let me mention just by way of example, something we discussed earlier, but I had a student a few years ago who wanted to do a thesis with somebody who was into bioethics problems. And he was given the problem of the giving or sale of blood. In Canada and many other countries, you can only give your blood away, you cannot sell it. But in Canada and in virtually all other countries where blood can only be given away, there is a shortage of blood products, of plasma, and that has to be imported from countries where presumably the ethics standards are not quite as high. Canada very seriously imports blood plasma, 60%. And I think in Italy at the time was even 80%. Plasma products has to be imported. For any surgery, you need these plasma products. Anyway, so the point was the student was given this problem as an ethics story. Once you discuss this from a law and economics point of view, you say, well, does the problem arise? Well, the problem arises, there's a market that doesn't function. Why does the market not function? Well, because we have imperfect property rights. A property right normally means somebody decides what's to be done with something that's scarce. In this case, giving or selling, but selling is an option. If you're not allowed to sell, you get an imperfect market, and imperfect markets mean that the price mechanism cannot do the adjustment it normally does, and so you get shortage. Once you're that far ahead, you say, all right, what is now of interest to us? Is there a country where we have gone from one state of the world to the other state, from giving away blood only to selling blood, and what happened in that country? So the student went through a number of countries to find out which might have gone through this transition. As it turns out, in the early 1970s, in the United States, one could give away, in the time of Jimmy Carter, you could only give away your blood. And then through a set of circumstances that don't need to retain us here now, Texas, I think, first, and then other states as well, said, well, yes, but for special kinds of blood, we should allow donors to collect money so that these wealthy beneficiaries of blood can get the blood they want. Once you allow it for wealthy people, there is a certain strain of egalitarianism in the American culture, you have to allow it for other kinds of blood as well. So Texas, I think first, but I'm going to be corrected if that's not accurate, allowed blood to be sold. And other states followed, and in due course, most states in the US now allow blood to be sold. Now, people then had this prediction, Titmus in particular, had this prediction that if blood can be sold, it will drive out the tendency to give blood away. So in the US now, interestingly enough, that thesis is disconfirmed because you have blood drives within universities, and people make it a point of pride to give their blood. At the same time, hospitals have lists of potential donors and are willing to call on these donors to supply blood, and the price to be paid may vary according to the state of the blood market, say. Anyway, we could spin this example out very much more, but the interesting thing is the student suddenly, by seeing this as a problem that can be analyzed through, as it were, the property rights template, had a number of research points to look at. That is something law and economics can do for a number of doctoral theses. For practitioners, law and economics can help you frame an interpretation of a particular provision, even in a code, that serves your particular case to plead. If you're negotiating complex contracts, law and economics prepares you for the idea that the solution you will find have to accommodate both parties. Contract is a win-win story. And so there's a space within which you'll have to find a solution. Law and economics prepares you intuition. So there's a message for practitioners as well. So I'd like to conclude with this broad idea. Law and economics should be part and parcel of any legal education in civil law countries as it is in common. Thanks.
Thank you, Professor McKay. And as you're finished with practitioners, I'd like to ask Professor Amato, Prime Minister. You have a huge experience, Minister of Interior of Italian Republic, twice Prime Minister, one of the biggest, economically, biggest countries of Europe. So, law and economics. So we had a discussion before. Which is the first one? Law or economics? Or economics and law? So law and economics. How, from your experience, how can we implicate it into our real life? How do we use it in our real life? Do you need this one? No,
Well, thank you, Valeriy. My main experience with law and economics was when I headed the Italian Antitrust Authority. And I fell in love with law and economics because I couldn't handle the cases without using economic analysis, which gives you in an area like that one much more than it usually does in every field of law. He is right. In every field of law, it gives you this a sense of the legal rule that lawyers by their own culture don't have. Any legal rule creates incentives and disincentives. This is what you learn from economics. And therefore you have to understand exactly the impact of your rule in economic terms. Under this light, any field of law is interested in law and economics. And a famous book, Economic Analysis of Law, by a great American jurist, Richard Posner, who also was a federal judge for years. He retired a few months ago. Applies something that is similar to what has been done also in his book, applies law and economics to whatever field, to antitrust, but also to tort and contracts, to criminal law, to sex. Because in any area, there might be incentives and disincentives that you have to understand. I give you, for a lawyer, if you study law, you are being taught that a legal rule is perfect when there is a sanction. If in Latin, the distinction was between perfecta minus quam perfecta, imperfecta, etc. And the perfection or not perfection of the rule was based on the sanction. Now, any economist will tell you that it depends on the sanction. Do I gain more by violating the rule without being discovered? Who cares about the sanction? So, which is, extremely important in the area of tax evasion. This is a continuous struggle. If you increase the brackets, does it lead you to more returns or less because people will try to evade more because the tax is too high, etc. So these are all arguments in relation to which you need economic analysis. Whenever there is an economic assessment of the pros and cons, even more interesting it is in the areas where people say it's not applicable. Let's say in the area of public law, several legal scholars will tell you this is out of the reach of economic analysis, because here no private interests are involved, but only public interests and public values. Yes, but what are the incentives for the politician, for the official to comply with the rule or not to do it? Here you will have a conflict, perhaps, between, let's say, the typical case of any political system where politicians are elected is increasing my public debt or reducing it and losing votes. Again, it's a very complex and difficult kind of assessment, because, of course, your public interest would lead you to ignoring the votes you lose, ignoring your private interest. But it is not necessarily so. If you want to understand the conducts of institutional figures and of officials, you have to apply also to them economic analysis to understand what is the prevailing interest in their decision-making machinery, etc. Also in private affairs, not economic, but of different kind. Think of divorce. What does prevail there? The desire to get rid of somebody, or the desire not to lose money. Economic analysis would lead you not to divorce. But perhaps your preference is to get rid of your husband or your wife. And from that moment on, you become a working poor very frequently, because you have to pay your former wife for the children, you have 2 houses, 2 flats to pay, you have 2 families to support, etc., etc. It is a disaster generally, economically. But certainly something else has prevailed. But again, this is something that people decide without any economic analysis. Should they learn something about economic analysis, perhaps the unity of the initial family would be more preserved, I wonder. But I want to tell you something about what economic analysis can give you when you have to assess the sense of a conduct, as he did in his first example of the polar bear and the amount of the damages. Here, the role that economic analysis has played in antitrust has been enormous, really changing completely the assessments based on the common sense of the lawyers, because so it was before economic analysis entered the field. Antitrust is based on a notion, restraint of trade. So any agreement or conduct in restraint of trade is prohibited. This is the formulation of the Sherman Act, the initial American statute that started off the new history of antitrust that had existed in common law, but not in these clear terms. Now, what is restraint of trade? As a lawyer, my immediate response is whatever restricts my freedom of contract. Because if you restrain my freedom of contract, for sure, you are restraining trade. It is not necessarily so. And so economic analysis will demonstrate to you that there are restrictions of contractual freedom that reinvigorate trade and competition. The case of franchising is the most well-known. In the case of franchising, in the relationship between the producer and the seller, there are several restraints that bind the seller. You can sell my product only in certain areas. You can, and a crucial rule that you could find in several initial contracts for, the supermarkets, these markets where you find whatever product, perfumes, and this kind of products far from fish. And the poor producers worried about the possibility that people had to buy this Chanel No. 5 close to the fishery, and therefore the smell of fish prevailed on Chanel No. 5, which was unfair. So restraining the freedom of contract of the franchisee, it was established far from the fish. And other rules, exclusivity, etc. The right decision of the courts was that all these restraints of the freedom of contract of the seller were instrumental to strengthening the inter-brand competition, because made these products, the products of this brand, stronger in facing other competitors. Price fixing. Price fixing is something that, in a purely legal view, is the worst of all restraints. And it was initially treated in jargon as a per se violation. If I see a case of price fixing, I don't even investigate the facts. If it is a price fixing, it's prohibited, full stop. There is no need to look into it. Little by little, by studying under the light of economic analysis, you understand that, again, it depends. It depends, because if I am the producer and he is the seller to the final consumer, if he wants a big profit for himself, he will add a high markup for himself that will increase the final price of my good beyond the level of products that are sold by somebody else. And therefore, my product is not competitive. Prohibiting this second price, so fixing a maximum price above which you can't go, I am not restraining competition, I am helping competition, and so on and so forth. There are other important examples. What is the limit that brought to its ultimate consequence? Economic analysis wants you to consider and to decide on the basis of the effects. And in jargon, we speak of effect-based approach. So a lawyer would say price fixing is by itself, it's a type of conduct that has to be prohibited. The economist will say, no, look at the effects. If there is an actual restriction of competition, you prohibit. If there is no restriction of competition, you don't. Effect-based approach. The fact of the matter is that frequently economists don't agree on the assessment of the effects. And we have had several cases in which the court found itself with the opinion of these economists saying, well, the effect is such as to restrict competition, and the opposite opinion by another economist. At that point, the court says, one of the values that cannot be renounced is certainty. A legal decision, a judicial decision, cannot depend on the uncertainty of these opinions. Therefore, and this has happened frequently, I go back to the typology of conduct. It might not correspond to what economic analysis would require and would assess, but at least it is certain, and companies know whether they can do it or not. And so we are now somehow in this conflict. So I can tell you, economic analysis is precious we couldn't live without it in several areas, but where it is mostly applied, such as in antitrust, in contracts, in damages, etc., it might create this tension. Instead of being an aid in the understanding of the law, it creates a sort of opposition with one of the basic needs of the law, giving certainty also for future conducts, which, let me say finally, it's a sort of undeserved satisfaction for us legal scholars, because, you know, when this story began, we, the lawyers, were the ones who had opinions, each of us different from the other. Obviously, lawyers generally give the opposite interpretation of the same rule and the same. So with lawyers, it's a disaster. There is no certainty. With the economists, it's completely different. Unhappily, there is this return to the certainty of the law, and silently I take note of it.
Thank you very much, Professor. Actually, we built today's discussion on two books from the beginning. First book, which is be available in Russian in very short time, was written by Professor McKay, and this is Law and Economics for Civil Law Systems. The second book is the book that is already available and in Russian, which I can show you. So, this is Concepts in Law and Economics, a guide for curious. But what I found now that probably, and we have to think about it, we have to think about publishing book of Professor Amato, which, because
I wrote a book.
I know, and this is Antitrust and Bounds of Power.
1997, which still sells copies.
About this book I'm talking now, because...
Give me the Russian readers.
Okay. So, as for Professor Leitzel, when I began to read your book, my first question was, why Nabokov? Why Nabokov? Nabokov, famous Russian writer. Of course, most of you knows him as the author of Lolita. But Professor Leitzel found his last book, which wasn't finished. And this is a whole story. And this story has a real connection with law and economics. So.
Well, thank you, Valeriy. Is this on? Hello?
Yes.
Okay. I'll follow my colleague's lead and use this microphone and stand up. Простите, мои русские друзья, я не говорю по-русски.
I don't speak Russian, unfortunately.
Speak in English. Although, unlike my colleague, I did make an effort to try. I didn't just say it was beyond me. I learned it was beyond me after making some effort.
Say that Professor Leitzel has a huge experience in not just in Russia. He spent more than a year in your School of Economics in Moscow. But Professor Leitzel had an experience and in the business school of Georgia in Tbilisi, and I think in Ukraine you had some experience.
That's true.
So you
Yes.
know the former USSR.
Yeah, I hope I know parts of it, and I know that
So probably you speak Russian, but you don't tell us.
Maybe. This is the title in English of the book. I just saw for the first time the Russian edition last night. So I could hardly be more excited. And I'd like to thank this edition exists because of Oxford University Press, which published the English language version, and the Gaidar Institute, which took on the task of interpreting the book or translating it. So that's the book. That's the title. Now available in Russian. I'm sure everyone brought their copy. Generally I don't talk about sort of how it became a book, but I will, today I will do that a little bit. I've been teaching law and economics for quite a while, and in the last class, sometimes I try to sort of summarize the quarter or the what we've covered, and except that's really boring because it just means you just go back over what you've already done. And anyway, the standard way of covering law and economics is to do it the way it gets taught, in a sense, using the topics of law school. So if you go to law school in the United States, in your first year you will take a course on property, and you will take a course on contracts, and you will take a course on accident law or torts, and you'll take a course on generally criminal procedure, on crime. And that is the way it's typically presented in law and economics as well, including in what is one of the leading textbooks in law and economics that is now in its 6th edition. I mention it here in particular because it's actually available for free now on the web. So if you're interested in law and economics, let me mention this is available for free, and actually it's for free in a legal way too. I mean, I know all books are available for free, but this one, it's available for free. The authors made it available. But they present it that way, and I think part of the reason that they present it in the order of property, contracts, torts, crime is because Judge Posner's famous book that has been mentioned by both of the previous speakers had it in that fashion as well, although eventually covered every topic besides those. Anyway, I found that unsatisfying, so I wanted to think more about the themes of law and economics that cut across these 4 areas. And so it turns out that the book, when I prepared this one lecture, the kind of structure of the book that emerged years later basically followed my summary, and I only really thought about it again today, and last night. So here are the 5 themes that I think pervade the area of law and economics. The first one is essentially the efficiency story. It says what we're going to look at when we look at a law is we're going to say what is its impact on economic efficiency? If you like, how efficient is that law? And we're going to compare laws on the basis of economic efficiency. And then many people would go the next step and say, a good law is a law that promotes economic efficiency. It's not just we're going to use it as a yardstick, but we're going to say the more efficient, the better the law. And this follows in the tradition of the gentleman in the photograph that his name has already come up. That's Jeremy Bentham, who, as a utilitarian philosopher, famously was interested in promoting the greatest happiness of mankind. So it turns out that the law and economics version of economic efficiency, often abbreviated by the size of the pie or overall well-being, is a close analog to what Jeremy Bentham was talking about back in the 18th and 19th century. I won't tell you the story yet, but I will mention that is, in fact, Jeremy Bentham. Many of you are familiar with this, but Jeremy Bentham's body is underneath those clothes. It's not his head, but the hair is his, and you can see it in London. If you get a chance to visit London, I'm sure it will be the very first thing anyone would want to see is Jeremy Bentham. But perhaps I will talk about that later. The second theme is, I'm sorry for the jargon, ex ante versus ex post controls, but it's the notion that there are various ways of regulating human behavior. Much of law waits until something bad has happened and then punishes the person who has done the bad thing. So crime is of that nature. Tort law is wait until there's an accident, and then perhaps the person who caused the accident will have to pay damages. Now, even though those strategies take place after the behavior occurs, of course, the idea for having them in place is to provide deterrence from antisocial behavior, if you like, before it happens. In a way, it's like it only comes into play, these penalties, after they have proven to fail in the case at hand, because they were ineffective at deterring. Ex-ante controls are controls that try to limit antisocial behavior again. Prior to the fact, many parts of human endeavor are marked by both ex-ante and ex-post controls. If you want to drive a car, you generally have to have a driver's license. Your car might have to be licensed. You might have to have insurance. Those are all before you've proven that you're a bad driver. But after you drive poorly and you hurt someone, or you just drive recklessly, then you might also pay penalties after the fact. A third element that you see across all sorts of law and econ analyses is the notion of offsetting effects. The idea that essentially we can take a policy, we can push in one direction, and it's not part of our intention, but it's often foreseeable that there will be other forces that then counteract our original intention. Perhaps not fully offset, but partially offset. One of the areas, this is so common, if you pick up a journal of law and economics, probably a third of the articles have some sort of offsetting effects story. So a common one concerns what happens if you punish something a lot more harshly, or don't punish things, or decrease punishments. For instance, some places have gotten rid of the death penalty. So they used to have a death penalty, and then they get rid of it. One of the things that you find happens when you get rid of the death penalty is that more of the cases, these are usually murder cases, that get to trial, that juries are more ready to convict parties, the offenders or the defendants, when there is no death penalty. So they offset, in a sense, the existence of the harsh penalty is offset by the unwillingness of juries to convict. And then when you can move it the other way as well. Who should bear responsibility and for what? We already heard a good example about that with respect to the polar bear. And the for what goes even further. It's like, the penalty, what you mentioned marriages as another possibility. So people at a wedding, they take a bunch of photos, and the photos are destroyed. Well, what is the nature of that loss? I'm very sorry. It's an emotional loss, essentially. I mean, it's something I cared about, but it didn't have much in the way of market value. Is that something that anyone should have? Is that a loss that we could hold someone other than the people responsible for? And of course, more generally, again, pointing to some of the things we mentioned earlier, what are things I can sell? What are things I can lose? Can I sell my kidney? Can I sell my blood? What if you just offend me? What if you say something that's terribly offensive, or if you have that bad smell from the fish? I find that offensive. Is that something, in economics, incidentally, I think many of you are familiar, as long as there would be a willingness to pay on the part of humans to avoid these being offended, that's enough to say, well, okay, that's something they value, and that makes a case for protection. But many times in law and economics, we put some of those things outside of the area of protection. John Stuart Mill, for instance, certainly did. And the last one says, and this doesn't have to be separate. In fact, I think in the future it won't be, but it still sort of is, because economics has typically accepted that people are rational when they make their choices. And we run through law and economics, and we come up with these theorems and these ideas about what's efficient, and then we say, well, gee, maybe people aren't so rational in the first place. Is that going to change our thinking about what a good law is? And the answer often is yes. And we should have thought of that 30 years ago, but we've only been thinking about that in the last 10 or 15 years. And of course, the most recent Nobel Prize winner in economics, Professor Richard Thaler, won the prize for behavioral economics, essentially how people behave in less than rationally. Okay, let's see. Okay, and the Nabokov question came up. I should apologize for my pronunciation of Vladimir Nabokov. I'm sure that's incorrect. But this is my example of law and economics reasoning. Like the polar bear example, this is one example. And it turns out, appropriate, I hope, for a Russian audience, that it actually starts the English language part of the book. We call him a Russian author. He was called a Russian author, but I think the Swiss might want him, and the Americans, and the French, and the Germans. He's an author. He's a world author. He perished while he was working on a book, and that's the sad part, that he did not finish his book. But the other thing about Vladimir was he told his wife not to publish his unfinished book. He explicitly told her, if he died and his book was not finished, that she should destroy the manuscript. So there I mention it. And what I want to suggest is that we think for a second. I mean, he asked his wife, but he could have written it into his will. He could have made it a legal document. He could have said, please destroy this valuable asset. And so the question I want to think about, at least, is, well, if he did that, if he wrote it in the will, and now it's you are in charge of executing, you're the executor of his will, do you have to destroy this, or can you just ignore this now dead person's wish? And you can, I don't know what your answer is, and as Prime Minister Amato pointed out, economists can give you answers on both sides. Well, I'll actually do it. I'll give you some arguments on both sides first. What is the case for publishing the novel? Well, of course, the case is, hey, this is something people really could value. What if it was as good as Lolita or Ada or all those other wonderful books that Nabokov gave us, even if it wasn't quite as good? Really, billions of people for millions of years. There's no end to the number of people in the future who might get some value from this book. That's a pretty big number. That's a huge benefit of having the book. And so if just because he wanted it destroyed, well, he's not here anymore. It's like, should we listen to that? Why deprive the rest of society forever, billions of people, because of his wishes? Well, I think you understand what the main case for destruction would be. The main case for destruction, well, maybe not, because it's the economic case for destruction, maybe not the first one that comes to mind. The economic case is the one about what the law is and what it implies about future actors. So if you are an older author and you're thinking about writing a new manuscript, and like Nabokov, you're nervous about your unfinished work, and not very good, presumably, work, at least in your mind, being made public, do you even try to start a novel because you're afraid you might perish and it would be published, and you would be sort of embarrassed beyond the grave at the fact that your novel was published? What if you get sick while you're working on it? Do you quickly say, I better destroy this now? And then you get better, and then it's like, oh, darn, I destroyed my novel, and now I'm better. I could have finished. So these are the things that might happen if you can't rely on the law to protect your last will and testament, right? So that seems to be the trade-off here with Nabokov, the Nabokov question. It's like, if we destroy it, we lose all the future value of all the readers, and if we do publish it, then we have to worry about future authors not producing their own great masterpieces because they're scared. And at that point, That's why we can disagree. It's like, which is larger? What happened in Nabokov's case was that his wife Vera passed away many years later, and then their son, Dmitry, in 2008, I believe, yeah, the manuscript was in his hands, and he was getting older, and so he said to the world, actually, he said, hey, I have this manuscript. My father wanted it destroyed. He told my mother to destroy it, but she didn't. And now I have it. Tell me, what should I do? He actually asked for advice. What should I do? So let's take a vote. Should it be destroyed? Destroy it? Destroy it? Who says keep it? Keep it. All right, I'm glad. I just want to see there were people on both sides. The majority was to keep it, and the majority, in fact, Dmitry listened to the majority. Dmitry did publish the book. You can see the odd picture of the cover because it shows his name and the title of the book. The original of Lara is incomplete because it's a very incomplete state. It consists of those 138 index cards. I don't think it's a great masterpiece and probably doesn't change much about the way we think about Nabokov, but at any rate, it is available, and that was Dmitry's decision. For those of you who think we should have destroyed it, I often would like to raise the stakes. I can think about a lot of other things that have been privately owned. Can we, at one time, for instance, the great building in India, the Taj Mahal, was built privately. What if you wrote in your will that when I die as the owner of the Taj Mahal, I would like to have it burned down? Why not? Because millions and billions of people would enjoy seeing the Taj Mahal, or even knowing that it exists. Maybe even if they knew, they wouldn't see it. They would know it exists. Is it okay? And by the way, why wait till you die? Is it okay if you own it to destroy it now? I don't know the answer, but I will say that again, the efficiency arguments are important here. Personally, I don't think you should be allowed to burn down the Taj Mahal if you own it. You are partly a steward. Ownership is kind of what society decides it means. We own our kidneys, but we are not allowed to sell them. Maybe we should be allowed to, but we're not. There's all sorts of things. What does it mean to own something? We get to decide. Okay. Normally, when I give a talk with PowerPoint, I have a laptop and I can see what the next slide is, but I can't do that now, so it's always a surprise for me, too.
Jim, can I give you one example from your book?
Sure.
Where I think we can be more clear what to do. Example of Parthenon in Athens.
Oh. Okay.
So, and it's not private.
No, it's not.
It's not private. It's not Taj Mahal.
Okay. If it's okay, I will just go through this slide once and then turn to the Parthenon. So what can we learn about law and economics by the simple example of the Nabokov proto-novel? What do we think about? We generally think about not the case that already happened, the accident that already happened, the book that was already destroyed. We think about what will this mean for the cases going forward. The laws we make today or the decisions we make today will have precedential value, at least in common law systems, and so will affect the situation in the future. Notice what we didn't talk about. I mean, you may have wanted to. Maybe it's a terrible omission. But when we talked about Nabokov, we didn't say, oh, he has the right. As the writer or the creator, he has a right. Or readers have a right. Maybe it's the right. Or justice requires. Of course, lawyers will talk about that. And maybe it's right that humans talk about justice and fairness and rights, but it's not the way of law and economics. It's about consequences and the value that people put on those consequences. It's not about fairness, justice, and rights. The Prime Minister Amato point, in the words of John Maynard Keynes, we can disagree. I actually like what happened in Nabokov's case. They waited something like 30 years, then they published it. I wouldn't mind seeing that to be the rule. If you have a particularly valuable asset and you want to see it destroyed, no. It's automatically converted to, we're going to wait 30 years and then it won't be destroyed. We'll put it off limits for 30 years, but then it won't be destroyed unless you really, really care. And then we'll make you run through some legal hoops so that you can opt out of the legal system. But anyway, I'm not arguing that that's the optimal rule by any means. I try to avoid the word optimal. But anyway, to the Parthenon. The Parthenon case that Valeriy has referred to concerns particularly that portion of the famous statuary from the Parthenon, the outside of the Parthenon, that exists not in Athens now, but in the British Museum in London. So about half of the extant statuary from the Parthenon is in London, about half is in Athens, and there's some little bits that are scattered around elsewhere. And the question is, it's a property dispute essentially, and so you would think law would have a lot to say about it, and then hence law and economics should have a lot to say about it. And so the question is, who owns it? Where should these marbles be? And again, the temptation is to start talking about justice. Well, the British have taken care of these marbles for 200 years, and it's a property of the law that ownership and they've been good stewards, they deserve it now, as the statute of limitations is run, the Greeks no longer have a claim, that might be one. Others might say, well, they haven't been that good of stewards, although the comparisons with the British marbles that went to Britain in the early 1800s compared to the ones that remained in Athens, in my mind, favor the British as stewards because they tend to be in better shape than the ones that stayed behind. Anyway, there are all sorts of arguments that you might make. One argument would be, you're worried about a precedent. Well, what if they return them? Does that mean that basically the entire British Museum has to have everything returned? Since that's not the only. What about that Rosetta Stone? What, they took that from the French, who took that? Come on. Don't we like these museums? Would that be the end of these sorts of museums? So these are the questions with the Parthenon marbles. What does law and economics say? Well, I won't give an answer, but I will tell you the most important result, most of you know it, in law and economics. It's the Coase Theorem, named after Professor Ronald Coase, who passed away some 6 years ago, perhaps. And Professor Coase says that as long as it's easy to move assets from one place to another, that it doesn't matter who the legal owner is, that it doesn't matter in one important sense who the legal owner is, those assets will move to where they're most valuable, because if it's easy to transfer them, then the transfer will take place. If I don't have a watch, but if I had a watch and it was more valuable for you to have this watch, it was worth more to you than to me, it's easy for us to come to a transaction and you would get it. Well, as long as it's easy to come to transactions, it doesn't matter if some court, the world court, says the Greeks own these or the British own these, or why not anybody else, by the way? There's a lot of the rest of the world. We don't have to restrict ourselves to those two. They would move to their highest valued use. That's the Coase Theorem, if it's easy to move them. And we know it's easy to move them, incidentally, since one of those Greek marbles from the Parthenon went to St. Petersburg a couple of years ago for a stay. Did anybody see it at the Hermitage when it was there? So these things can be moved. So that's the Coase Theorem. And let me just say, okay, that doesn't, again, standard economics, it doesn't actually resolve the question. But it does suggest something, because it's not just that the marbles, that where they end up is independent of who the official owner is. It also suggests that where the most valuable location is, or therefore where they end up, is independent of where they happen to be right now. So this suggests the thought experiment. What if all of the Parthenon marbles were in the Acropolis Museum in Athens right now? They were all there instead of half of them. together like they had been for 22,000 years, 2,200 years before they got moved to Britain? What if they were all together? If you believe that they should be in London, then imagine they're all together and somebody says, you know what, I have a good idea, Acropolis Museum. You should take half of these marbles and send them to London. If that's the highest valued place, the British and the Greeks could agree to an agreement and move them there. I think that that would be laughable. That nobody would think, that's a great idea, we'll take half the parts of them. And by the way, if you're going to move them, you should move them to Asia, where 40% of the population lives and is much further away than, I mean, Athens and London are fairly close. Move them to Asia if you want other people to get to see them. But at any rate, to me, that's actually a strong argument that they belong in Athens. By the way, the argument of why they belong in Athens is an aesthetic argument. It's about the viewing experience available in Athens. And I won't go into details. I've never been there, actually. But it's a better location, I would say, for seeing the marbles. But I could be wrong, and I don't really care. I do want to, though, use this, if I may, Valeriy, to talk about that idea about what if people aren't rational. And all I want to turn to here is one little element of the work of Richard Thaler, among others, that has occurred in the last 30 years, and that concerns the famous endowment effect. So the endowment effect, I won't give you this, it's the usual story of the endowment effect is this microphone, before it became mine, my willingness to pay, the most I would have been willing to pay for this microphone was 10 rubles. But now that I have it, and it's mine, if you offered me 30 rubles for it, I would say no, it's... And just minutes ago, I thought I would not have been willing to pay 11 rubles for it, but now I will turn down an offer of 30 rubles. That's an example of the endowment effect. My mere ownership has changed my valuation. I place a higher valuation on it. So what does this do with the Parthenon marbles? See, what Coase tells us is that where an asset ends up is independent of where a court, of who the court says is the owner. Whoever the owner is will then trade with whoever, it doesn't matter who the court says is the owner. But if endowment effects are important, then when the court says, you own this microphone, then suddenly your valuation of the microphone goes way up. And now, it's no longer the case that where it ends up is independent of what the court says. Where it ends up is precisely whatever the court says, because that becomes the highest valued use. So if a court were to tell the British that they own the marbles, if endowment effects are great, then that might become the highest valued use. So that's shows you how you can completely turn a sort of the main theorem of law and economics, if you like, on its head as soon as you talk about preferences in a way that we've only become comfortable with doing in the last 15 or 20 years. Oh, I guess I have more slides, but it's a surprise. Oh, yes, because Prime Minister Amato is here, I could not resist saying that we all of this Jeremy Bentham stuff, but we owe a great Italian many thanks for being a precursor to modern law and economics. I like to have a slide that says, what is law and economics? Because in my experience, most lawyers do not know what law and economics is. Most economists do not know what law and economics is. It just applies the microeconomic principles to the analysis of legal rules and institutions. It asks, what will be the consequences of alternative rules? It will measure those consequences on an efficiency basis, and will then usually say that the more efficient rule is better. That's all. I want to thank everybody, and especially for the translation.
Thank you, Professor Leitzel. What I'm thinking now, that in all this discussion between law and economics, There are a lot of topics to discuss them. We have to start maybe from morality. What is moral? What is immoral? When we are starting discussion from, first of all, law or economics. Sometimes, in some cases, at least that I found in your book, for example, the idea and the example of Parthenon, and as I remember in your book, in Antitrust and Bound of Power, you have a whole chapter, Heritage of History. So, if we are talking about morality, ethic, which is ethic, which is non-ethic, and starting from the first idea that you had in your speech about blood, organs, kidney, which is moral, which is immoral for what legal system or for just society? Why in one society this is quite normal and in the other society it's do you remember this essay, The Way of Law, by Judge Holmes?
Oh, Path of the Law.
Yes. So, the Path of Law. It was the essay of 1897 from American judge of the highest court, which proposed to immoral persons, and he decided that the immoral person is a bad guy, bad person. So to fix a price list for his actions, to think about the actions based on the price list. If you want to do something, this is a price list and you have to pay. And if you are going to do this, you have this price list and you know, and your attitude to yourself as just as for the price list. So, moral or immoral, ethic, non-ethic. If we are talking, for example, about black market, in the theory of law and economics, how we can discuss the Iranian program of kidney, if it's moral, it's immoral, or how can we use it in our life?
Well,
Yeah.
sorry. Maybe an interesting place to go back to is a book by your compatriot, or former compatriot, Guido Calabresi, called Tragic Choices, 1978. And say we will not allow contract, the kidney store and so forth, because we don't want to allow people to put themselves into desperation contract, making choices that affect them in their fundamental values, or leading us to trade-offs which we find immoral. Calabresi, I remember a lecture he gave in Toronto, and he said, well, we have this fantastic remedy for all sorts of ills that affect society, but we can only apply it if one person may be sacrificed. But we say this is not acceptable. Morality limit. We don't like desperation contracts. It's the old argument against purely utilitarian arguments.
That's a great example that you just gave. And that is a strong argument against utilitarian philosophy. It's not actually a strong argument against the law and economics efficiency approach, because the law and economics efficiency approach uses so-called Kaldor-Hicks efficiency. And so this idea about some wonderful remedy that requires the sacrifice of one person, in law and economics, that would only be more efficient in the Kaldor-Hicks sense if that could be arranged as a voluntary deal, at least in theory. That is, if the people who would benefit from the remedy could pay enough money to the person who would be sacrificed, that he or she would be willing to accept the deal. So in that sense, it's not quite as strong an argument against law and economics as it is against at least one version of utilitarianism. So I guess I was trying to promote law and econ there.
Continue then. What if the one person who you think might sacrifice herself goes into that desperation contract?
Yes.
Rationality, should you say no, the law should not allow you to put yourself, to sell yourself into slavery?
Yes. So if this person was truly desperate, had a great need for money, and had family members who needed money, perhaps he or she would accept a large payment in exchange for their life under those circumstances. Whereas if they had more resources, there would be no amount of money that they would accept for this trade. That does get us back to the difficulty that you've described. Do I have? I'm not sure I can resolve this problem. I feel like I had something to say about it, but I've lost it momentarily. Let me appeal to my...
I want to say something else, because this case is a case where the position of Guido Calabresi is firm, because he is against the death penalty, and whatever leads to the death of somebody which is not an accident or sickness or whatever. The case that I have handled in my court in these weeks, which I very much feel, and where ethics prevails in my view on anything else, is the case of, as we say in Italian, surrogacy, when a woman cannot, for several reasons, withstand the pregnancy, and another woman sells her body to host the future child, and gets pregnant and delivers the child, and then the child is given to so-named intentional parents. Perhaps he is the father. Quite likely she is not the mother. There might be the possibility that, but the case I had was only the father. The intentional mother had a cancer, she was treated, several reasons, etc., etc. And the other woman was an Indian woman. She could have been a Bangladesh woman. And you have these two cases in the world, really two different cases. The poor woman who decides to accept, because by doing this, she will nurture her children. She is a poor woman. This is a wonderful opportunity to get some money. Generally is no less than $30,000 that in Bangladesh are sufficient for years to raise children. The opposite case is we generally say the American girl who is in this market that has to do with making babies, and for the same amount of money, she is ready to spend 9 months of her life with this pregnancy, and she will use this money not to raise children, but perhaps to go to Europe for a summer. Now, in my view, this is deeply immoral. This is something I can't accept.
In both cases?
in both cases, the idea, and here in my view, ethics prevails on everything, the idea of a woman that uses her body as any kind of service in the market, service provider in the market is, in my view, unacceptable, both in the case of purely market affair and in the case out of need. My decision, I don't enter into it, but my decision was this can't be accepted, and therefore there have to be consequences due to. Now, economic analysis would lead to different outcomes. I don't know, because in terms of efficiency, it is efficient. We want, now I make the opposite case, the opposite to mine. We want a child. For one reason or another, we can't. There is really an objective reason that prevents us from producing ourselves the child, and therefore we can avail ourselves both of technologies that now exist and of the consent of women that for different reasons are ready to help us. So why should we waive our desire, not to say right, to have children for this reason? We don't offend anybody. We don't kill anybody. We don't injure anybody. We give to other persons the opportunity to do something they could not. So in terms of economics, I see this as the prevailing reasoning. And in this case, not in cases of antitrust, I say no. This is a kind of efficiency I reject. Can you say something against this?
Could I add a rider to that case? First, let me say that Marie-Anne Frison-Roche in France takes exactly the position you say. Any woman lending her vital organs to carry babies for others, in her view, is engaged in a form of slavery. But let me add the case that happened in Quebec. Here's a homosexual couple. They can't have children. A friend offers to carry the baby, one of the couple being the father, and she herself, totally consenting. She knows what it implies. There is no payment. There is a friendship service.
The case of friendship
And,
is different.
well, yes, but she consented. She was fully aware. When the baby was born, very happy, the woman is introduced as some form of relative, new vocabulary, but she said no, not for a second child. Is this consent invalid? Should we not trust you to make decisions for your own good?
This is something that is considered different. Actually, the position, because there are no legal regulations at the moment except for general prohibitions of these things. But our legal doctrine distinguishes continuously between the case of relatives or friends, the mother for the daughter, the sister for the sister, the friend for the homosexual couple. So when it's out of the market, when it's a donation, where is an act of participating to a future family somehow, not remaining out and selling the body. So this is, the outcome is the same.
But if the Western couple went to visit the Bangladeshi woman and said, we will cover all of the costs associated for you to live for 9 months in a rather controlled environment, would that change the nature of the consent the woman gives? In many cases, these women know what they are engaging in, and they know that the benefits that they get will help their families. Should we question their consent that much?
My answer, which is not necessarily mine, I'm not like Woody Allen, who generally agrees with what he thinks, but is that the compensation in money is considered a divide between two different typologies of cases. This is what I read. But you might be right that the distinction is not so solid.
The problem is then with the temptations of money.
Yeah, that's
Okay.
Yeah,
And then we have a question from the audience.
You reminded me of actually what I was intending to say, so I really appreciate that. Yeah, the temptations of money. There's the famous line in Romeo and Juliet when Romeo is trying to buy poison. It's illegal to sell poison, but he finds a famished apothecary, a druggist who is impoverished, and the druggist says, "My poverty, but not my will, consents." Right? Of course, and Romeo says, "I pay thy poverty and not thy will." But with respect to the family thing, the mother-daughter, there's a lot of coercion in family situations as well. We have to distrust consent in both these areas. My family, but not my will, consents. So that's one I want to say. But the second thing is what is efficient. And this is really an area where, again, behavioral economics and what rational choice is changes your thinking. When can we count on people to be rational? Well, it's hard to count on people to be rational in any circumstance. But when it comes to a decision that you're going to make again and again, like what to have for breakfast, and you get feedback, and you can see if you made a mistake, I'll never have that again. These are the sorts of things we expect you to choose well. But the sorts of questions that you're asking now, should I bear a child for another couple? Those are, generally those are not repeat questions, and you don't get much feedback. So the level of consent required for that has to be quite strong to make us, to have a high probability that this really is an efficiency enhancing. Everyone is going to be made better off by this exchange. So that means you have to explain all the risks. You have to have waiting periods so that people are, and possibly it does mean that that people who are in relatively desperate circumstances are excluded from that potential market.
We have a question.
Thank you very much for a very interesting discussion. I would like to get back on more practical track. Thanks a lot to our speakers for an interesting. Thanks a lot for a very interesting discussion. But let me discuss it from a more practical viewpoint, because in international legal practices there is already a kind of a tool we're used in such questions, the institute, the regulation of input assessment. So there are certain tools, pros and cons, benefits, and certain moral points can be assessed from the viewpoint of pros and cons, costs and benefits. So even during the war, so they consider how many people will die in a given scenario, for example, so as to provide the sufficient number of medication, for example. For example, when you think about one person or hundreds upon hundreds of people who might die in a certain conflict. So maybe Mr. Amato heard about this, the input assessment tool. So have you used this instrument, this tool in your practices in terms of interaction, connection between law and economics? We are evaluating the economic and social consequences every time we deal with such questions. Thank you.
This kind of assessment was made in our age was when the nuclear bomb was thrown in Japan. The American explanation was fewer deaths than with the war continuing for months and perhaps for years. Therefore, the net gain is that only 100,000. Of course, perhaps they ignored the consequences also on future generations, and therefore the damage of this kind of thing should include also what will happen to those who are affected by the radiations, etc. But this is something that really I tend to adopt Calabresi's position. There are some absolute limits that you cannot trespass, and making, this thing of more and less is something that I can easily apply to tax evasion. If I increase the tax, do I increase also tax evasion? So I don't do it. If I eliminate this old factory, do I reduce employment or not? Because I can create other opportunities for these workers, etc. Here I might apply this kind, and I have applied it repeatedly, but you have to be careful about the areas.
Could I add a little rider? Perhaps you remember the famous Bhopal case in India, right? Union Carbide had a factory in India, and they produce very toxic chemicals. An enormous explosion occurred in India, and I think 1,800 people died, and a number of people were seriously maimed. The question then arises, should the victims sue under Indian law with the implicit value that Indian law attaches to human lives, or should they be allowed to sue in the United States, where Union Carbide has its headquarters? Implicitly, the value we attach to human lives determines the level of precautions we're going to take. If you would allow the Indian victims to sue in the United States, you're applying precautionary standards that have implicitly developed in the United States to a reality that's quite different. But what it means is that human life does not have the same value across the globe. And we experience that from day to day in environmental questions. It's a very practical thing.
Разрешите вопрос?
Professor Lotto, Department of the Market Substitution. Dear speakers, thank you for interesting topic, but I would like to ask the following question. During turbulence of the establishment of the world, the law and economics have to do with politics, and my question is, to what degree in your countries the law and economics are influenced by the political factors?
Thank you for the question. I'm not sure I'll be able to answer it, but what I will say is that law, it's hard for me to, I mentioned some of the classes that I teach, and I teach a class called Public Policy Analysis. And it's hard for me to know whether law and economics is a subset of public policy analysis, or whether public policy analysis is a subset of law and economics, or if they're the same thing. The sort of the whole cost-benefit approach is essentially the idea of the sort of efficiency analysis of the size of the pie that law and economics uses as its first step. And then to pass a cost-benefit analysis for a law or a policy is to increase the size of the pie in aggregate, even if some people end up with smaller shares or smaller slices. Does that mean that it's a good idea to pass such a reform? And the cost-benefit analysis can't answer that. It can tell you whether the pie is likely to get bigger or not. That is an argument that it's a good idea, but it's not the last word. So how it affects politics is, well, I'll say two things, and this is the civil law versus the common law tradition here. So one potential argument, and the argument for law, the rules that come out of the system serving efficiency, is that within a common law system, there's various arguments, but there might be evolutionary forces, if you like, that tend to eliminate inefficient laws and promote efficient laws. There's well-known arguments. That, in the United States, that means that things like constitutional law, which are common law, if you believe that, there's a tendency towards efficiency. But with respect to statutory law that's passed by city councils and states and the federal government, then you don't have the same standing requirements that you have for actual legal cases where people's that you only can bring if you have standing. So that's a situation for a different type of lobbying. And how well that serves efficiency it's to my mind, it's less likely to serve efficiency. In fact, probably what is more helpful for efficiency in that case is that in the United States there are 50 different states, and they, at the state level, can make laws, and some of them will appear better than others. Sorry, I went too long.
It's a good point, because here you have the economists having different opinions themselves. All of the OECD countries years ago introduced a wonderful tool that is the analysis of impact of regulations impact analysis, RIA, which of course should give you the precise and objective assessment of the effects that your regulation is going to produce. And therefore, when you present a bill, you are supposed to accompany the bill with the analysis of impact, which allows the parliament to correct the bill in relation to the desired effects or not desired. It's an improvement. It reduces the arbitrariness of political choices, but it is subject to the influence, in the best case, of different positions of economists, in the worst case, of different lobbies. And therefore, the poor parliamentarian that has to decide find himself or herself in a very difficult position.
So it seems to me you had a question. Huh?
Is it okay? I think so. Well, Mr. Amato, did you misuse the word outcome and output? Because I think that economic thinking is fully input-output thinking, and not input-outcome thinking.
I don't remember when I used the word outcome.
Yeah, you used the word outcome.
You are certainly right.
Yeah, okay.
I want to thank the speakers about. I want to thank you for interesting reports, and I've got one question for all of you. What is your opinion about the concept of efficient breach of contract?
Perhaps I can start if it's okay. I have a microphone. So for those of you who don't know, there's an argument that the standard measure of damages in many common law countries is something called expectation damages. That's the damages meaning damages for breach of contract. So if I sign a contract with you and then I don't do what I promised, how much do I have to pay you? And the standard answer to that question is we have to say what kind of position would you have been in had I completed the contract? I have to put you in the same position if I breach the contract. That's the standard measure of damages, and when you analyze that in terms of economics, it means that when I make my decision whether to comply with the contract or to breach the contract, the decision that I make as best for myself will simultaneously be efficient, will serve society's ends, because you are indemnified. You are indifferent as to whether I perform the contract or I breach the contract and pay you an amount of money that makes you just as well off as if the contract had been complied with. That's the theory. Now, in practice, and there's other issues about so-called reliance expenditures. It's more complicated. But in theory, it works very well. It induces efficient breach versus compliance decisions. However, in practice, there's elements of how you feel about it that will not be protected. That person who loses the polar bear footage is going to be very upset about the amount of money that they get in expectations damages. If you were expecting as a business person, you were going to purchase an input and you were going to use it in your production process and sell it and make profit, in general, you're not going to be able to collect that profit when the contract gets breached. So in practice, it seems, even forgetting about how expensive it might be to go to court and litigate this matter, which is itself it could be quite significant, it's unlikely that you will be fully compensated. And that means that it probably is the case that when you're making a decision whether to comply with or breach a contract, you will breach more frequently than you should from society's point of view, because you're not really going to put the breached against party in a position where he or she is indifferent between compliance or breach. And you might not even have to go to court, and you recognize that as well as something that will protect you. If it's small stakes, you're not going to spend a lot of money to take me to court about it.
Could I add just a small argument? First of all, in contracts, any risk that runs around is internalized by the parties. You know that the other party may breach and that you will not get fully compensated. You factor that into the price you're willing to pay for the contract. But to put a very practical spin on the question of efficient breach, let's go back to the times when you booked an airline seat, and if you didn't show up, well, then that's just too bad. The airline flew an empty seat, and that much loss, other passengers had to pay for you. So the airlines started to practice overbooking. And the first thing that happens, you might say, this is a breach of contract. You have a promise of contract of transport, and so you don't perform because you've given the seat somewhere else. So what do you do then? Well, I forget who it was who said, well, just organize little auctions. And indeed, that's what started to happen. And look and behold. And now you say, if there's overbooking, they call for volunteers. And those volunteers will be paid a premium. Flying a full flight is less expensive for all of the passengers than flying a three-quarter empty flight or a quarter empty flight. So what have we got here? Everybody seems to win. You fly for less, those who are apparently damaged and consent to a compensation formula, in the end, all of us fly for less than we would otherwise. We waste fewer resources in flying planes than we would otherwise. So the sort of efficient breach mechanism combined to an implicit auction brings us to a win-win situation for all of us. So maybe this efficient breach thing is not such a drama as it's made out to be.
Another practical question, if you wouldn't mind.
We have time just for one question, and
That's probably mine.
okay.
Nice. First of all, I would like to tell that for those of us who was born in USSR, for my opinion, is pretty natural to think in terms of law and economics in general. And my question is the following. What do you think of practical value of third-party beneficiary doctrine in contract law or common law in general? Or another additional question, if anyone covers these issues in your research, would you please elaborate on it?
Could you elaborate a bit more what you think the friction points are?
As far as I'm concerned, third-party beneficiary approach значит, по-русски это звучит.
In Russian, it sounds the concept of the third-party beneficiary.
In English, it sounds third-party beneficiary doctrine. This is a part of contract law. Previously, it was kind of part of British law. Now I believe this is the heritage of the whole common law system. And I think this is the potential for development in the area of law and economics in general, because those forms of partnerships as private-public partnerships, project finance in general, they always focus their attention on a final consumer or even those benefits which are not seeable for the first time. Do you understand what I mean? No? Okay. That's why public-private partnerships, the biggest example.
Can you specify your question?
It was pretty specific. I'm pretty satisfied. Thank you.
That's something to do with trust relationships. Third-party beneficiaries. I'm not sure. Yeah, no, I associate what you're asking me with trust law and the introduction of trust law in civil law systems as well. In trust law, you have a person who establishes a trust, and there's an administrator, and then there's the trustee, and then there's the third-party beneficiary. It turns out that this is a very useful formula for transmitting assets. But to delve into that is a long analysis. But indeed, all civil law systems have now tried to find ways through the fiducia of bringing in the advantage of the trust formula into civil law systems. Sorry, very sketchy answer.
Okay. So, as time passed, I can say that I have a lot of questions more. No, I just look into my mentions, and we didn't discuss property and real rights, intellectual property rights. it's, yeah. So from the crookwood of humankind, it's very interesting story, yeah, Kant. If we will conclude our discussion, we will finish in 1 week, I think. But we have 3 books. One book is available now in Russian. The other book will be available very soon. The third book we discussed today that we need to translate it. So, I hope that after today's discussion, your knowledges will be rich and you will have the desire to read these books and to find the answers. Thank you very much.